Thank you, Justice Black. This hearing is in the matter of case number CFI 090-2021 before Justice Michael Black. The claimant is represented by Khalifa bin Huwaidan al-Kitbi, advocates and legal consultants. Lead counsel is Mr. P.V. Danish. The fifth defendant is represented by Hamad al-Rahma, advocates and legal consultants. Lead counsel is Mr. Arshad Ghaffar.
Thank you very much. So, Mr. Ghaffar, this is your application.
Your Honor, yes, it is.
But before we start, let me at least tell you where my thinking is at, having read most, if not all, of the documents. So your client maintains not only did he not sign the facilities agreement under the heading of personal guarantor, but he signed none of the documents. Is that right?
Your Honor, yes.
And it's his case that he did not give Mr. Adas authority to sign any of the documents on his behalf.
Well, Your Honor, that we say is not really an issue at this application, because what really matters is whether or not the signature in his space under personal guarantor is his signature or not.
Well, I'm not, Mr. Ghaffar, I know that's your case. I'm not entirely sure in my mind that that's the correct analysis. Because I have to say that I am surprised that neither side has independent forensic documentary analysis evidence. As far as I understand it, you rely solely upon the letter from the police to the court, don't you?
Your Honor, yes, we do.
And no one has seen the underlying forensic report, unlike the BankMed case, where I've seen on file that there is a reasoned report which led to a decision which this court found bounded in relation to the forgery issue. And indeed, I understand that Mr. Adas was sentenced, received a custodial sentence, which he may or may not still be serving. I haven't worked that out. But at the moment, my initial view is that that letter alone is not even evidence. It is second-hand hearsay because it is saying the police have received another letter from the Forensic Sciences Department, which presumably recites the contents of a report. So we're at least two steps away from that report. So I have some difficulty, I have to say, at the outset in considering that that is even admissible evidence on the forgery issue, which you're going to have to persuade me on. And of course, this is a strikeout and an immediate judgment case, not the trial of the issue. But I'm equally surprised that the claimants faced with an allegation of forgery haven't themselves obtained independent forensic evidence, which I would have thought would have assisted the court, given the contents of the defense in this case. So I'm at the moment rather feeling that this application is somewhat premature.
Well, Your Honor, that may well be the case, but the trial of this matter is scheduled for May of this year.
Yes.
And we don't have much time between now and the trial before we can get this issue resolved. And it obviously needs to be resolved before any trial, because the evidence at trial, Your Honor, will not be any different. There is no direction for expert evidence for either of the parties.
Well, it may be different if I give a direction for expert evidence.
Your Honor, you may do that, but Your Honor, in that respect, we rely on the comments of Nur Hinadi.
But that was an entirely different situation. Even if those comments are binding on me, which they're clearly not, she's a registrar, But the position that the registrar was facing, and in my view correctly dealt with, was that there was a final judgment. Well, there was a judgment which was subject to confirmation on appeal in the criminal courts in Dubai, and once that judgment was final, it was binding on the DIFC court. We're in an entirely different position from the one that faced the registrar here, because we have no judgment. All we know is that there's an ongoing police investigation.
Your Honor, that's correct. But the report of the Dubai police and the statement by the Dubai police, we say, is as a matter of the law of evidence, which you should be applying, whether it's the English law of evidence or the UAE law of evidence, is admitted in proof as proof without any further need for.
But subject to the weight that I give it. And if I regard it, as I do, frankly, as second-hand hearsay without seeing the underlying documents, I'm going to give it very little weight.
Well, Your Honor, we would urge that it be given the weight that it should have as a matter of the proper evidential framework. I mean, our case is simply that this is a document, an official document issued by a public authority in Dubai, and it cannot be gone behind. We cannot question the veracity of that document or its probative force.
Well, but it's not. But it's not the document. It's not the report. It's a second-hand hearsay account of the report. If I had the report, then you could make that submission. But I don't think that submission even gets off the ground. If we're dealing with just the letter, and even if the submission got off the ground, I think I would take some persuading that I'm bound, whatever the adequacy or inadequacy of the reasoning of the report, to bound by its contents. The Baghdad case was different. There was a judgment of the Dubai Criminal Court, and I accept that we would be bound by a judgment of the Dubai Criminal Court under the judicial authority law. But I think we're in a very different position where there's just a report, let alone a second-hand report of the report.
Well, Your Honor, the position with the report is that it's not available to the public until the Dubai police concludes its investigations.
Exactly.
However, the DIFC court can always request a copy of that report, and that is between the DIFC court and the Dubai police. So if you need to see a copy of the report, we would urge the court to request that copy from the Dubai police, because they won't release it to us. But the report has plainly been issued and has been written up and has been relied upon as backing up that letter.
But there isn't even a file that's been passed to the public prosecutor yet, is there?
Your Honor, there isn't, but in our submission, that is not really the relevant issue, because as a matter of the law, and if I could just take you to some of the relevant law.
Yes, please do.
Articles 7 and 8 of the Federal Evidence Law.
Where do I find that?
Pages 318 of the electronic bundle.
Right. So that's 3. When you say 318, is that 3-18?
Your Honor, yes.
Yeah. Okay, I have that.
That says the formal writing is a document in which a public officer or a person in charge of public service records, in the manner prescribed by law and within the limits of his powers and competence, what has been performed in his presence or statements that have been made to him by the concerned parties. So we would submit that the letter from the Dubai police is a formal document. It is a formal writing. And unless it is legally established to be a forgery, going on to Article 8, it has probative force erga omnes as regard matters therein recorded, performed by its author, within the limits of his duties or in respect of matters performed by the parties in his presence. So that, Your Honour, we say is the starting point.
And why am I bound by the UAE law of evidence as opposed to the DIFC law of evidence?
Well, Your Honour, there is no DIFC law of evidence on this particular point, as far as I've been able to ascertain.
So then we're English common law.
Your Honour, yes, in English common law under the Civil Evidence Act 1995 says at section 9, and you can find that, Your Honour, at page 4-35 of the bundle.
And before we do, can we just travel a little further through the UAE law on the base so that I can understand it and understand your case? So official statements. So a formal document is a document of a public officer or a person in charge of service records in the manner prescribed by law within the limits of his powers. Okay, the document. Okay, so let's assume that the letter fulfills the criterion under Article 7.1. Then Article 8, a formal writing, unless legally established to be a forgery, has probative value, erga omnes, as regards matters therein stated, recorded, performed by its author within the limits of his duties. Okay, so you would argue that that document evidences the existence of a report. When the original, well, we've got the original, and the original document does not exist, we've got that.
Not just evidences the existence of the report, Your Honour, but it also records, if I could take you to the letter from the Dubai police, that's at 3-12.
Yes, okay.
And that says, as a result of the report, it was found that after conducting the technical examinations, it was found that the aforementioned did not make the signature attributed to him in the document subject matter of the complaint.
Yes, I mean, it's a bit vague, isn't it, as to which signature it's talking about and which document?
Well, the complaint, Your Honour, is at 1-289 to 1-304.
Okay, that's helpful.
1-289 to 1-304.
Okay, criminal complaint. Let me just have a quick read through this. So you've already got a forensic report, according to this.
We have, Your Honour, we just have not submitted it into evidence in the DIFC court because we have no direction for expert evidence, nor do we feel that we need it, given that the matter has been investigated by the Dubai police, and they have concluded that the signature on the facilities agreement is a forgery.
Well, I have to say that's a very bold position. Sorry, now where does it identify which document? The banking facilities.
At page 1-291,
Yeah.
it exhibits, refer to exhibit number 1 from the attached bundle of documents.
Yes.
The signing of the same agreement on behalf of Fast Telecom. So the document
on
in the
behalf
complaint,
of Fast Telecom, so that's not on his own behalf. So this is, you see, I'm trying to, the signature that you're complaining about is the one in his own name as guarantor. And you've been very careful to confine this application to that.
Your Honor, yes, but the document that has been subjected to analysis by the Dubai police is the facilities agreement.
Yes, but I don't know what the analysis is, and I don't know which signatures.
Well, Your Honor, we would submit that it's all of his signatures that appear on that document that have been subjected to analysis.
But I have to. But you're applying to strike out or for summary judgment, and you're asking me to make evidential assumptions.
Your Honor, we appreciate that there is something lost in translation in the letters, which are originally in Arabic, and this complaint was originally in Arabic as well.
Yes, of course, I understand that, but rather than being at the stage of trial, to be at this stage, I have to be absolutely precise. I mean, particularly given the seriousness of the allegations that are concerned. I mean, if one had irrefutable proof that it's the particular signature that you're concerned with, and that there were a report which was unarguable, I can see the case. But once one has to start making inferences, I'm very concerned that it's not an appropriate case for immediate judgment.
Well, Your Honor, in our submission, there are no inferences to be made. If you read through the complaint fully, it is quite clear that the complaint is that his signature as a guarantor has been forged, and that is the basis on which this action has been brought against him.
Well, where does it say that? Just direct me to the words that I can make that finding on.
Well, Your Honor, if I could take you to page 1-293 to 1-294.
Yeah.
The complaint is, we find that the respondents have entered a signature and name written in the credit facilities agreement dated 4th of January 2016 and falsely attributed to the complainant in order to obtain from him the personal bank guarantee stipulated in the agreement. So that is plainly a reference to his signature as a guarantor.
Yes, that's right. You're right about
that. And Your Honor, there are other similar sections in the complaint. So the complaint is plainly that his signature as a guarantor has been forged, and as of his other signatures on the facilities agreement as well. And it's in response to that complaint that we have the Dubai police letter, which I'd taken Your Honor to earlier.
Yes.
In which it says very clearly that the making of the signature is not attributed to D5. Did not make the signature attributed to him in the document subject matter of the complaint.
Yes. Okay, I think you may well have joined up the dots on that one.
I'm grateful to you, Your Honor. Your Honor, furthermore, there is also the, going back to the point Your Honor was making about whether or not there's been a decision of the criminal courts or not. Your Honor, can I just take you to the document that's the criminal procedural law, which has been exhibited to the statement of the claimants in reply. And if I could take you to page 3272 of the bundle, 3-272.
Yep.
As a matter of the criminal procedural law, Articles 181 to 183 apply to what's known as the ancillary action of forgery. And if you look at Article 182, Your Honour, it says, should the court examining the action deem that the decision to be taken is dependent on the challenged paper, that is a paper that's been challenged for forgery, and there is a reason to proceed with the verification of the evidence to such forgery, it has to refer the papers to the public prosecution and stay the action until a decision is reached in the forgery by the competent authority. Now, in our submission, the competent authority is plainly the forensic department of the Dubai Police, which operates in collaboration with the public prosecutor. And we would say that is reflected in the documents in the Bank Med case, which you can find, Your Honour, at 1/258, 1/260 to 262.
Is that's the transcript?
No, those are the actual decisions in the Bank Med case.
Okay. Sorry, give me that reference again.
1/258.
Yeah.
And 1/262.
Okay.
So Your Honour will see at 1/
I have 258.
258. That is a certificate from the public prosecution, and it certifies that the criminal report at the Dubai police station is submitted by the claimant against the appellant on charges of forgery in an official document, and the report is submitted to the public prosecution under
Yes.
X number, and the case is still under investigation. If you go on to 260 to 262,
yeah,
that is the Dubai Police General Headquarters, represented by the General Department of Forensic and Criminology, extends to you their best compliments and greetings with reference to your letter dated 30th of March in respective case filed under complaint number X in Dubai Police Station.
Yes, I mean that's the report, and indeed I looked at the report and I looked at the methodology that was used, and that prompted really my remarks at the beginning of this hearing that this is what I would have expected to have seen rather than just a letter about it.
Your Honour, yes, the only submission I'm making right now is that the competent authority, as far as the criminal procedural law is concerned, is the General Department of Forensic and Criminology at the Dubai Police Force. So that even if there were a criminal case brought pursuant to the criminal procedural law, and there was any issue as to the forgery of the document, as a matter of Article 182 of the criminal procedural law, the report that would be relied on is that of the Dubai Police as the competent authority, as verifying the forgery.
Yes.
And if you read that with Articles 7 and 8 of the evidence law, that report has probative force erga omnes. Now, I appreciate you haven't seen the report, but you have seen a letter from the Dubai Police verifying that report and verifying that the signature attributed to the fifth defendant in the document subject matter of the complaint was not made by him.
So, sorry, just let me let's see. Yes, so federal law. So the reference to competent authority, sorry, is in the federal law, Article 182, isn't it?
That's in the criminal procedural law, Your Honour, yes. And
Okay.
that is a federal law as well, yes. Federal law number 35 of 1992.
Yes. Sorry, can you give me, sorry, forgive me, I just lost slightly the reference to the evidence. You wanted to refer to the evidence law as well.
Your Honour, yes, and that is at
You just need to give me the reference. You've read it to me, but
3-18.
3-18, yes?
You're on a yes. And that's Federal Law number 10 of 1992 on evidence in civil and commercial transactions.
That's the evidence law. I'm not sure you did take me to that specifically, but okay. And which article?
Article 7 and 8, Your Honour.
Article 7 and 8. Okay. Yeah, oh, yes, sorry, yes, of course you did. Yes, sorry about that. Yes, you took me to that. So I just didn't get the reference down properly. Lovely. Sorry, I interrupted.
That's quite all right, Your Honour. It's important to establish that these points are good to start
Okay.
with. So Your Honour, our submission is basically very straightforward, which is that the report from the letter from the Dubai police is an official statement, which, as a matter of the federal evidence law, has probative force erga omnes. There is no DIFC law of evidence on this matter. English law of evidence, similarly, as a matter of Section 9 of the Civil Evidence Act, says that an official statement can be put into evidence without further proof. Your Honour, I'm not sure if I took you to the Civil Evidence Act.
You didn't. I think you gave me the reference, but you didn't take me to it. Do you want to take me to it?
Your Honour, yes, if I could. That's at page 434-35 of the electronic bundle.
Thank you.
And Section 9.1, a document
Yes.
which is shown to form part of the records of a business or public authority may be received in evidence in civil proceedings without further proof. So we say that the document of the Dubai police force is a document of a public authority, and it may be received without further proof in civil proceedings as evidence. Without further proof simply means that it has the force that should be attributed to it without it needing to be in any way proved or in any way established as verifying the facts that it records. But Your Honour, in our submission, if one looks at the DIFC court law, Article 50, and that, Your Honour, is at 3-237.
327.
237.
237, sorry.
That concerns the application of evidence. And that says where proceedings are instituted in the DIFC court, the rules of evidence to be applied in the proceedings will be the rules that are prescribed in DIFC law, A, or B, are applied in the courts of England and Wales, or C, the DIFC court considers appropriate to be applied in the circumstances. Now, we say there are no prescribed DIFC law rules of evidence to be applied in this circumstance. The law of evidence the rules of evidence that would be applied in the courts of England and Wales I've just taken you to. But we would say in any case, it is more appropriate in this matter for the DIFC court to apply the UAE federal evidence law, because the dispute is subject to UAE law. The Dubai police have been engaged and they have issued a forensic report, which, albeit you haven't seen it, you have seen a letter verifying that report and the fact that the signature attributed to the fifth defendant in the document that's complained of, the facilities agreement, is not his. And we would say that's sufficient.
Well, I'll come to that. At the moment, I'm just looking at the probative value of the letter. I want to come to how far the letter takes you in due course.
Your Honor, yes. But in any case, our position is that the more appropriate rules of evidence to apply are the UAE Federal Evidence Law, as opposed to the English Civil Evidence Act.
Yes.
And if you apply that law, it is quite plain, as a matter of Article 7 and 8, to which I took you earlier, that this is an official statement, an official writing, and it should have probative force erga omnes.
Okay.
So, Your Honor, hopefully that does connect the dots, as you put it.
Yes. So let's move on to where that takes us. So let's take the letter at face value, if we may, just to look at the text of the letter, which I've got elsewhere. Do you have a bundle reference for the letter?
It's 3-12.
Thank you very much. 3-12. So let's assume, for the purpose of argument, that this letter, that I'm willing to accept this letter as evidence that, as it said, then the fifth defendant did not make the signature attributed to him in the document.
Your Honor, yes.
Okay, that's as far as it goes, isn't it? I mean, all the evidence uses the word forgery, illicit, and so on. But those are inferences to be drawn from the fact that he did not affix his signature. Let me say that I find, as a matter of fact, that this is conclusive, that he personally did not affix his signature to the facilities agreement under the rubric of personal guarantor number 1. Okay, so then one is in the realm, isn't one, of inferring that that was affixed by somebody else with a fraudulent intent, and indeed your defense suggests that the bank and Mr. Adas were in collusion. That's your case.
Well, Your Honor, it is our case on the pleadings, but we don't need to go that far on this application, because this application is brought on the basis that the sole claim against the fifth defendant is based on that signature being his. And if it is not his, that claim must fail, because there is no proof that he ever personally guaranteed the obligations of the first defendant under the facilities agreement. None whatsoever. It does not matter who affixed that signature as long as he did not.
Well, I'm not sure that's right, is it? I understand precisely what you're trying to achieve in narrowing the issue in that way. But wouldn't it be open for a judge at trial, whether it's me or somebody else, to infer from the surrounding circumstances that they have no proof that the other signatures, which are apparently his, attached to a suite of documents which form part of a transaction whereby a company of which he was a 51% shareholder enjoyed a facility of up to $12 million. And if there is no evidence that those other signatures are also forged, then isn't it open to that trier of fact to infer that whilst he may not have been the person who affixed his signature to this document, nevertheless, it is at least an arguable issue that it was affixed with his approval.
Your Honor, the only way in which one can get to that is if there is a power of attorney granted by him to somebody to affix that his signature with his approval. And the evidence on the power of attorney, such as it is, firstly, it doesn't authorize the attorney to affix the signature on a guarantee document. So there is no authority to do that.
Are you sure about that? The power of attorney refers to banking documents.
Your Honor, it does, but a guarantee is a separate obligation that is severable from the loan facilities. And it takes effect as a contract of its own.
Yeah, I'm not sure. Again, perhaps we ought to look at the the power of attorney if you want to make that submission.
Well, Your Honor, there is no pleaded case on the power of attorney whatsoever. The power of attorney has only been raised in the evidence, and it has only been raised in respect of the asset pledge agreement. So, Your Honor, I'm not sure that we need to go that far in any case. And as far as the evidence is concerned, the power of attorney is only relied upon in respect of the signature on the banking facilities, on the loan facilities document.
I mean, I will accept that, frankly, on both sides, this case could have been pleaded a lot more clearly. There's a lot. There's a lot that one has to struggle through to get to the essence of this case on the pleadings on both sides. But what I'm trying to do is to cut through it and think about how one will approach the matter at trial.
Your Honor, at trial, we say the issue will be very straightforward. The claim against the fifth defendant is brought purely in his capacity as a personal guarantor. The only issue that will then arise is whether or not his signature as a personal guarantor on the facilities agreement is genuine or otherwise. And we say,
not just that, it's whether or not it was affixed with his consent, whether pursuant to the power of attorney or not.
Well, Your Honor, yes, to some extent that is the case. But the evidence before Your Honor today is that it wasn't affixed with his consent. And there is no evidence contrary to that.
Well, the bank is not in a position to do anything other than raise inferences. And which is the normal position where you're talking about well, unless you can prove that they were in on the fraud. I mean, let's assume for the moment, on the basis of the BankMed findings, that the most likely scenario would be that Mr. Adass was trying to set up a loan to the company, which he would then milk for his personal gain, which you would say is the position. If there is no collusion with the bank, the best the bank could do in all of those circumstances would be to raise an inference that your client, that's not the case, but that your client consented to the arrangement. It couldn't give direct evidence, and could it, about what Mr. Adass was doing or not doing, unless, of course, it was a co-conspirator.
Well, Your Honor, I recognize that fact. Your Honor, the further evidence that is uncontradicted, which the bank could put evidence in as to, is that my client, the fifth defendant, had no involvement in any of the business of the first defendant from about 2013, 2014 onwards.
But it doesn't say that. I mean, the loan, it says the contrary. I mean, it does need evidence, doesn't it? On the loan opening agreement, it says that all of the KYC procedures were undertaken. His signature there appears under his photograph, and it says, you know, that it took his passport and Emirates ID details. Doesn't the court have to hear that evidence? Because your client has pleaded that he didn't do that. And so isn't it a critical issue that the court has to decide as to who's telling the truth on that issue? Because if your pleaded case is found to be false, that and it's found that the bank did observe the KYC issues, and that your client did in fact sign the account opening document in 2015, then looking at it as a matter of inference, the court might be persuaded that even allowing for the truth of what is asserted in the police report, your client nevertheless consented to the affixing of his signature to the personal guarantee.
Well, Your Honor, that is one way of looking at it. However, in our submission, the documents that have been, the account opening form is simply the opening of a current account. It has nothing to do with the loan facilities whatsoever, except that the signature relied upon as the bank having done its KYC on that account opening form. The bank says it didn't need to then look any further into the signature on the loan facilities document because it had that account opening form signature.
So, I mean, does your client accept that he did sign the account opening form?
No, Your Honor, he doesn't. He says that all of his signatures from 2015 onwards, as appear on any of the documents, are not his.
So isn't it a really important issue for the court to decide as to whether or not that's right?
Well, Your Honor, to the extent that there are any relevant documents that have been submitted to the Dubai police for forensic analysis, and I appreciate that the letter from the Dubai police refers to a document singular, but in our submission that is a mistranslation, and the actual Arabic does refer to documents and the nuances of translation.
What am I to do on an application for immediate judgment when the documents say one thing and you tell me they're not accurate.
Well,
I mean, are these matters that will have to come out in the wash at trial?
Your Honor, there is nothing to come out in the wash at trial as such, except that there is a statement from the Dubai police. There was 3 or 4 documents submitted to the Dubai police by the claimants themselves.
But where's the evidence of that?
Well, Your Honor, the evidence is in the claimant's skeleton argument and in its reply. And if I could just take you to the reply.
Yes.
At paragraph beg your pardon, Your Honor, I'm just trying to find
No, you take your time. We've got plenty of time.
It's paragraph 18 of the reply at 1/319.
Paragraph 18. Okay.
And that says, as per paragraph 9, the 5th defendant mentions...
Just bear with me when I get to it. Okay, I have it. Sorry, you want to take me to it, yes?
Yes, and the claimant has submitted the defense memo and shall be producing the original documents, namely the facilities agreement dated 4th of January 2016, credit facilities letter dated August the 4th, 2015, statement of accounts, and working capital limit credit facilities letter April the 10th, 2016 to the police station. Now, the proof that those documents were submitted is in the skeleton argument of the claimant, in which it says at paragraph B3 at bundle reference 4-5, on May the 10th, 2022, the respondent duly submitted its defense before the police station.
Sorry, sorry, B.
It's bundle reference 4-5.
B3, is that right?
Yes.
Yes.
The respondent had produced the original documents, namely the facilities agreement, credit facilities letter dated August the 4th, statement of accounts, credit facilities letter April the 10th, to the police station for the verification of the signature of the applicant.
Okay. And so where does this take me?
Well, Your Honor, the claimant itself has submitted 3 documents to the Dubai police for verification of the signature of the applicant on those 3 documents. One is dated the 4th of January 2016, which is the facilities agreement which we're concerned with. The other is a credit facilities letter dated the August the 4th, 2015, which the claimant has not put into evidence, which is not before Your Honor today at all. And that is the original letter whereby the loan facilities were sanctioned, i.e. agreed in principle.
Yes.
And then it has put in the letter dated the 10th of April 2016, whereby the credit facilities agreement of the 4th of January was varied, so it was reduced from 12 million to 6 million.
Okay, I've not seen that either, have I?
Well, Your Honor, I can take you to that if you'd like. That is at one 126 to 1128.
Okay, let's have a look at that. Yes, I've not read this one. 10th April 16. Prosecution.
Your Honor, it begins, please refer to our sanctions letter dated August the 4th, 2015, which, as you've just seen, was submitted to the police by the claimant for verification.
And there is what purports to be your client's signature, bottom right-hand corner, you can see.
Your Honor, yes.
Yeah.
Now, these are the documents that have been submitted by the claimant to the police for verification of my client's signature. And the police have reported, or the police letter says, that his signature is attributed to him on these documents.
No, it doesn't say on these documents. That's the problem.
Well,
it says the document, the subject of the complaint.
Your Honor, that's correct. But it stands to reason that the police have analysed all the documents that have been submitted to them.
They may have done, but I haven't seen the results of that analysis. That's not on the record. That, for me, just reinforces what I said at the beginning, that the court really needs to see what precisely is in the police report. And indeed, it's not for me to advise the parties, but I should have thought that, in addition, the parties would want their own forensic evidence.
Your Honor, the position on the party's own forensic evidence, my understanding is that the parties have relied very much on the comments of Noor Hinadi in the CMC.
But then they're being misguided, because what the registrar was talking about was Article 5A4, wasn't it, of the Judicial Authority, or A54 of the Judicial Authorities Law, where the court is not able to entertain and has no jurisdiction. As you say in your own skeleton, it's about jurisdiction. It has no jurisdiction to entertain an issue which has been effectively decided by another court. It's about the operation of the doctrine of res judicata. It's not about evidence.
Well, Your Honor, she does say very clearly as well that the police report itself is something that cannot be gone behind.
But that's fine. So we don't go behind the police report. But it doesn't answer the question that I said before as to whether or not your client consented to his signature being affixed to that document in the light of the surrounding suite of documents, none of which has been subjected to forensic analysis, yet all of which he alleges are forgeries.
Well, Your Honor, in our submission, we don't need to look at the surrounding suite of documents. They are
well, that's your submission, but and that may be a submission that prevails at trial, but on an immediate judgment application, I can see an argument that in the context of the surrounding suite of documents, the inference the court should draw is that your client's signature was affixed to the personal guarantee with his consent. That's all I'm concerned about, as to whether that is a fanciful argument or not. And at the moment, it doesn't seem fanciful to me in the context of the overall transaction.
Well, Your Honour, the evidence is to the contrary, and there is no evidence contradicting that position, if I can put it that way.
Contradicting which decision, sorry?
The position that he has not affixed his signature to any of these documents.
There's no direct evidence. I accept that completely.
So, Your Honour, the position really is then left at, would my client on cross-examination at trial be found to be telling a lie?
Yes.
And we say that is highly unlikely, particularly in light of the uncontradicted evidence as to his illness at the time and as to his lack of engagement with the business of the first defendant. And Your Honour, more to the point, before the first drawdown on this loan occurred, notwithstanding that the credit facilities agreement is dated the 4th of January 2016, the first drawdown on this loan didn't occur till the 2nd of May 2016.
And he'd relinquished his shares in April of May. April is 2016.
Precisely, Your Honour. Your Honour, the statement of account, which verifies that the first drawdown was until the 2nd of May 2016, is at 1/151.
Okay. Yes. I'll take your word for it. It's I'll twist it over by 90 degrees when I come to read it. At the moment on screen, it's in
I appreciate that. And
in
if you
landscape,
rotate
but I'll
one
read
document,
it. Yeah.
you have to rotate all the others.
Okay.
And Your Honour, there seems to be no dispute based on the skeleton argument of the claimant that indeed the shares were sold in April 2016. And furthermore, and this is the claimant's advocate giving evidence, but we don't object to that in this respect, that
you agree to the fact.
Well, the respondent, this is at page 4-10 of the bundle in the skeleton argument of the claimant. They submit that the amendment to the Memorandum of Association for the sale of shares was notarized in May 2016. So they appear to accept that the sale of shares was effected and the Memorandum of Association of the company was amended. They simply say that as per clause 14.4 of the facility agreement, it explicitly stated that the borrower further undertakes to the bank that it shall ensure that there will be no change in its shareholding without the prior written consent of the bank. But there is no dispute as to whether or not that shareholding was changed. And if the borrower has breached his obligations under clause 14.4 of the facilities agreement, that has nothing to do with the fifth defendant. Your Honor, there is some suggestion that the bank was aware of the change of shareholding at the relevant time, and that is the.
Right? I mean, is it relevant? Is it a relevant issue?
Well, Your Honor, simply to this extent that if my client's truthfulness as to his lack of engagement with the business of the first defendant is to be questioned, then the fact that he has sold his shares prior to any drawdown under these loan facilities is plainly of relevance.
It is, but and it would be at trial. I just wonder whether it assists me at the moment.
Well,
And
Your
more
Honor,
importantly, whether it is relevant to the issue of immediate or summary judgment, or whether it's just adding another layer of evidential complications which
well, Your
may
Honor,
have to be investigated.
simply trying to respond to the suggestion made by Your Honor that the only basis on which it could be said that the claimants have more than a fanciful chance of success is if the fifth defendant is shown at trial to be telling an untruth as to the fact that.
Well, that's not quite that's not quite what I said. What you said was that your client would have to be found to be a liar. That would be a result if one elevated the inferences to be drawn from the suite of documents to a finding.
Your Honor, as I say, our primary submission is that the suite of documents is irrelevant to this application and to the claim against my client as a personal guarantor.
I understand your submission.
And we say that the court need look no further than that. There is only one basis on which this claim has been brought against my client. Indeed, the other documents are not part of any cause of action that has been pleaded against any party in this claim. They are simply being put in as ancillary documents and referred to in the pleading as being, as he's put it, part of a suite of documents.
But they do have they may have evidential relevance.
Well, they may do, but they don't have any evidential relevance to this particular issue, which is whether or not his signature as a personal guarantor is actually his signature or not.
Okay.
Your Honor, if I could possibly take you just to the pleadings.
Yes, of course.
And the way in which this claim is advanced against my client. The particulars of claim only mention the fifth defendant in 3 discrete paragraphs. And if you look at page 1/22, paragraph 1.6 simply puts forward an address for the fifth defendant.
Yes.
So that is not really relevant to the issue we're dealing with today. Paragraph 3.3.1, fourth and fifth defendants were the personal guarantors for the facilities.
Yes.
And the only other mention of the fifth defendant at all in the pleadings is at paragraph 10.3, where it is said it is to be noted that the following checks provided by the first defendant duly signed by the fifth defendant. Now that is demonstrably incorrect because if you look at the checks, they were plainly signed by the fourth defendant.
But I mean, this is not a very good pleading, I have to say. And I mean, what is the relevance of those checks?
Well, Your Honour, precisely. We would say they're not relevant, but the point I'm trying to get across, Your Honour, is that the
I mean,
only
the pleaded case is that he was a guarantor, and that demand was made, and he didn't meet it, and that's all that needed to be pleaded. The rest of it is just flummery, isn't it?
precisely, Your Honour. So the reference to the other documents is simply unnecessary on the pleaded case.
Yes.
And they do not evidence anything as far as the pleaded case is concerned, nor do they have any relevance. They are as relevant to this issue as the judgment and the evidence in the Bank Med case are to the allegation that the documents have been forged. They are similar fact evidence, if anything.
Well, I'm sorry. Well, we're getting highly technical. I mean, Bank Med is certainly similar facts. That you're right about that. I mean, the problem is that what's been pleaded here is evidence rather than pleadable fact, and I mean, this is background evidence from which certain inferences could be drawn, but it's not pleaded very well as to what those inferences are, and query whether it's necessary strictly as a matter of pleading to plead evidence rather than the facts upon which the claim is based, rather than how those facts are to be proved. But it's a technical distinction between similar fact and evidence from which inferences to be drawn. But I get the point. I mean, we're talking about evidence. We're not talking about causes of action.
You're on, absolutely. And the sole basis on which this application has been brought is that the claimant has no reasonable prospect of success on its pleaded cause of action.
Its pleaded cause of action is very simply, as I understand it, your client was a guarantor. He didn't meet his guarantee, therefore he's indebted.
Precisely. Precisely, Your Honour. Now, in terms of the defence to that pleaded cause of action, there are two relevant paragraphs of the defence, which if I could just take Your Honour to.
Of course.
One is at page 1/250, and that's paragraph 2A. And there, the fifth defendant says very clearly, the claimant has filed a present case praying for various reliefs on the basis of the alleged facility agreement, asset pledge agreement, account pledge agreement, all dated the 4th of January 2016, and sanctions letter dated 10th of January 2016 and 10th of July 2017. That should read the 10th of April 2016. The alleged documents, which are forged and fabricated, and on this ground alone, the reliefs as prayed against the defendant cannot be and ought not to be granted by this court, and the case be dismissed with costs.
Yes, I mean that's a matter of over pleading, really, isn't it? I mean the claimant has filed the present case on the basis of the signature as guarantor in the facilities agreement. Again, the rest of it is background evidence.
Your Honour, yes. And paragraph 6B at page 1253 is very clear as to paragraph 21 to 62. The defendant denies that he signed the facility agreement, guarantee, other documents, etc., for and on behalf of the first defendant, Fast Telecom, or as a personal guarantor for the payment of dues or at all. Now, Your Honour, if I could just take you to the reply. So that is a clear plea that he didn't sign as a personal guarantor.
Yes.
Paragraph 3 of the reply at page 1/316 is responding
Yes.
to paragraph 2A of the defense, which I took you to earlier. And that simply says when the claimant had received the facility documents, the claimant was not having any suspicion about the signature of the fifth defendant, since the claimant had taken all the compliance procedures and formalities for the availment of the loan. Hence, the claimant was sure it was the signature of the fifth defendant and not forged. Now, Your Honor, that isn't a positive plea that the signature is genuine. It's simply a plea as to the belief of the claimant.
Well, I mean, these are not the best pleadings in the world. I'm willing to interpret that as saying that they took the necessary KYC procedures and form. If what is the point of saying you took the necessary KYC procedures and formalities if not to verify the signature? I mean, I admit it's a poor, it's a poor pleading, but I certainly would construe it as saying that they took the compliance and clearly the genuineness of the signature is an issue. There's no, when you get down to it, the issue is a simple one, as you say. Is it a genuine signature or not? If it's not, then I think where you and I may part company is where does that take us?
Your Honor, yes. If I could just take you on to paragraph 9 of the statement of reply,
Yes.
which responds to paragraph 6B, where there is an express allegation by the fifth defendant that he didn't sign as a personal guarantor. Paragraph 9 simply doesn't address that point at all. It says, as for paragraph 6B and 6C, it is alleged that the fifth defendant was suffering from critical health conditions in 2016 and had withdrawn his involvement in the partnership of the first defendant and denies signing any of the facility documents. The claimant had gone to the borrower's office to get the documents signed. That is the extent of the plea in paragraph 9.
But again, doesn't it? Again, it's not a great pleading, but I would expect at trial evidence to be given by the person who went to the office to get the signature, saying I went to the office and got the signature from the fifth defendant. That's what it means, doesn't it?
Well,
now, whether that's true or not, it's for the trial judge to decide.
But, Your Honor, they appear to accept that the signature has been forged. And again, if I could just take you to their skeleton argument at page 4/5, paragraph B5 of the skeleton argument, they appear to accept that as per the letter dated November the 10th, 2022 from Dubai Police, it was mentioned that as per the forensic report, Mr. Bagouthi's original signature does not match that on the facility documents. So they have not questioned the Dubai Police report. They have not put in issue as such the genuineness of the signature on their pleaded case. And Your Honor, at trial, the only issues that the court will be faced with are those that have been pleaded by the parties. And the evidence at trial is not going to be any different from the evidence before Your Honor today. Subject to the obtaining of the actual forensic report from the Dubai Police, which, as we say, it is entirely for the DIFC court to request, because until the police have concluded their investigations, that report is confidential to the complainant, is confidential from the complainant and to the public generally. the evidence at trial as to forgery will be the letter from the Dubai police.
So you are not applying for the court to obtain the report from the police?
Your Honor, if it's necessary, if Your Honor feels that it would assist the court, obviously the trial date would then have to be delayed and the entire matter effectively stayed until that report is received. But if Your Honor feels that it would assist the court to have that report, then yes, we would make that application. But we say it is not necessary because there is a letter from the Dubai police that verifies the contents of that report. That is an official statement from a public official, and that has probative value erga omnes.
Okay.
Your Honor, there is no issue in this particular case that the claimants have as such behaved fraudulently, despite the pleading.
Well, your client, forgive me, your client alleges that in his defense.
Well, he says he has a suspicion that they have colluded with the first defendant.
It's a bit stronger than that, isn't it? Again, I have to say that the defense is no better than the particulars of claimants are pleading, to be brutally frank.
Well,
It's a bit all over the place.
Your Honor is quite correct in that respect. But on this application, the issue of collusion between the claimant and the first defendant in respect of the forging of my client's signature is of no relevance.
Well, it's alleged that the claimant, with the malafide intention to mislead the honourable court, has approached this honourable court making false and incorrect allegations on oath and concocted and put forth a story against this defendant as regards alleged payment has failed to substantiate or produce evidence that the defendant was in contact with the claimant at the time of executing the alleged disputed document, or any time otherwise, and that the due diligence was carried out by complying with KYC requirements and prevalent laws. I mean, there is an allegation of the most serious nature.
Your Honor, yes, but that has no relevance to this application today.
Well, I'm not sure. I mean, what is being alleged is that the claimant bank is guilty of fraud, complicity in forgery, and has misled the court on oath.
Your Honor, whether or not that allegation is true or untrue has no bearing on the issue of the forgery of the signature on the guarantee document. It is a serious allegation, I appreciate that, and it simply reflects the heightened emotions of the parties in this case, if I can put it that way.
I see that. But people shouldn't be throwing around allegations like that unless they're willing to prove them or able to prove them.
Your Honor, it is not necessary for us to prove or otherwise disprove for that allegation at this application.
Yes.
I appreciate that has led the parties down a rabbit hole of effective irrelevance as to whether or not the KYC was properly conducted or otherwise.
Well, it takes us back to where we get to, even if I accept the truth of the report. And it takes us back to the question as to whether or not, even if it's not his signature, whether it was affixed with his consent, and whether that can be inferred from the surrounding circumstances, including evidence that he personally did sign other documents within the suite of the documents creating this transaction.
Well, Your Honor, there are only two other documents in the suite of documents. And those are the asset pledge agreement and the account pledge agreement.
But he denies opening the account at all.
Your Honor, yes, but that is a current account opening, which has no relevance to the loan facilities. Whatsoever. It is a completely separate issue.
But he denies any relationship whatsoever with this bank.
Yes, Your Honor, he does.
So if the finder of fact, trial judge, finds that the account opening document is genuine, that would undermine his credibility in relation to all the other issues, wouldn't it?
Well, Your Honor, it cannot undermine the fact that the signature has been forged. Or
no,
has been
you use the
affixed.
word forged. That the signature has been affixed to that's a value judgment, if I may say so. The facts are that he is not the person who wrote that signature on that document. That's all the police say. Now, usually I accept that if somebody puts somebody else's signature, a copy of somebody else's signature on the document, it is usually a forgery, and it is not a difficult push to go from somebody affixing a facsimile of somebody else's signature to a document to forgery, but we haven't got there yet. Between the affixing the signature and the finding of forgery comes the question of authorization. And if there is surrounding evidence of authorization or consent, then that may disprove what would be the normal situation.
Well, Your Honor, I accept that point. The difficulty that the court is faced with today is, of course, if the court doesn't grant us immediate judgment and the matter proceeds to trial on the basis that Your Honor is indicating, and assume at trial it is found that the signature was affixed with the consent of the fifth defendant, there is then a separate criminal prosecution brought against the alleged forgers of that signature by the public prosecution in the Dubai criminal courts. And that court then finds that those alleged forgers are in fact guilty of the forgery, as they were in the Bank Med case. We then have two irreconcilable judgments, one of the criminal court of Dubai, the other of the DIFC civil court, and it just places the courts in an invidious position.
But there are at least two levels of contingency in that submission. It depends what either of the two courts find.
Your Honor, yes, it does. But is it a risk that the court will wish to entertain?
I don't think it's a risk the court could avoid if it's not a reason to give immediate judgment on the basis. I don't think there's any authority for the proposition that you give immediate judgment to avoid an inconsistency with another judgment. The principles are clear as to whether or not. I mean, this isn't a strikeout case at all, frankly. I mean, the pleading, bad as it is, discloses the cause of action. So we're in summary stroke immediate judgment territory, not in strikeout territory. But I can't see any authority for giving summary judgment on the basis it is possible that judgment at trial may be inconsistent with judgment in another jurisdiction.
No, Your Honor, I simply make that submission to draw home the consequences of
possible consequences of possible findings in two different court cases.
Your Honor, yes.
That's not your strongest point, I think.
Your Honor, I accept that.
Okay.
Nevertheless, it is something that the court should have in mind in our submission.
I hear that.
Your Honor, there is equally the issue that any reliance on a criminal or on a document that is not genuine, if I could put it that way, is a criminal offence as a matter of the laws of the Emirate of Dubai and of the UAE generally. And that is brought out by Articles 216 to 222 of the penal law.
But that is a bootstraps argument, because the genuineness of the document depends upon the finding as to whether or not the signature was authorized. The question for me is it so improbable that the signature was authorized that I want to give immediate judgment? I mean, that's what it boils down to. Isn't that right?
Well, Your Honor, if I could just take you to Article 216 of the
Of course, I'm not going to stop you
penal
taking
law.
me wherever you want, yes.
And that is at 3-75. And that defines forgery of a document for the purposes of the penal law. And Your Honor is right, because at 2165, one of the elements of definition of a forgery is if it is done without the consent of the owner of such signature, seal, or fingerprint. But the other elements are in 1 to 7 of Article 216 are, we would say, made out in this claim.
Mm-hmm.
And the consequences of anyone relying on a forgery with knowledge of such fact are that they will be subject to the statutory penalty for forgery, and that's in Article 222. Now, given the report of the Dubai police, in which there is no indication whatsoever that the fifth defendant consented to his signature being affixed in this way, and it is a purely forensic report based on the signature, then we would say that any reliance on the alleged forged document exposes the party relying on it to criminal penalty under Article 222. And that is the basis on which the complaint was made, the original complaint to the Dubai police, to which I'd taken Your Honour earlier.
Yes.
So in our submission, the claimant is putting itself at severe risk by relying on this document as being genuine in light of the Dubai police report.
Isn't that a matter for the claimant?
Well, Your Honour, it is. But again, we would say that that is a significant factor for Your Honour to take into account in determining whether or not this is a matter which has a fanciful as opposed to a realistic prospect of success.
But I mean, I'm no expert on UAE criminal law, but as you say, 2165 talks about affixing a signature without the consent of the owner. And might not the claimant say, well, the issue is whether that consent existed or not?
Well, it might well do, Your Honour, but of course, that is a speculation as to what might occur in any criminal prosecution that is brought against the claimant based on 222. But for present purposes, we would say that it just goes to the fact as to whether or not the claimant's pleaded case is fanciful or realistic.
Okay.
Your Honour, I think you have my primary submissions. And if you've read my skeleton, you will appreciate that there are other arguments that are raised by the claimant as well, which in our submission are not strictly relevant to the primary issue. So unless I can assist you on any further.
No, thank you very much. Thank you very much indeed. That's the submission is extremely helpful. Thank you. Mr. Dinesh.
Yes, Your Honour. I'm sorry,
Yes.
I was on mute. Yes, may I proceed?
Of course.
Yes. I'm very thankful to my learned friend who candidly stated the facts and honestly stated the facts where he could not fill up the dotted lines. He admitted that. First of all, my learned friend, the fifth defendant, is confining only one document among the soup of documents or fleet of documents. That is the facility agreement. And this is a case for recovery, a civil suit against 5 defendants. And he's a guarantor. The forgery has been taken as a matter of defense. When the defense comes up with an argument of forgery in a normal banking transaction, I need to probe it further and answer the question. Where I cited the power of attorney, it's not the case that first time it was introduced. Since it was raised as a matter of forgery, I took up the issue of power of attorney, and power of attorney is on record. I can take this honorable court to the power of attorney. It's a very sweeping power of attorney. It talks about facilities. I don't need to take the time of this honorable court by looking at it. I can just give the number 3-211, printing page 598. It's a quite sweeping power of attorney. It talks about banking facility. Would my lord wanted to see that document? I can take my lord's. If
sorry, 3-211. 3-211.
I'll just take the document then straight away.
Yes, I have it here. I have read it, but do take me to the sections that
Yes. It's quite sweeping. Running page is 598. So sorry, 598.
Is that 598 in
the running page in the case bundle, electronic bundle?
Okay, yeah, yes. So I have both actually.
Yes, that
Yep,
3 dash.
okay, yes, I see.
I'm sorry, 3-211. That is 598
Yes.
running page on the left hand side top corner.
Yep.
So kindly come to the bottom of that first page, 3-211. Somewhere in about 15 lines towards the bottom.
Yes.
And all other banking, all terms, which is a very, very, very sweeping document. And signing on my behalf in all bank transactions. On the left-hand side, behalf in all banking transactions.
Yes, I have that. Signing on my behalf,
yes.
all banking transactions.
All checks, deposit cash, funds, checks, draw and transfer the same to open the documentary credits and transferring the same, covering or uncovered and tender the securities required. The attorney has to sign, right to sign, the bank facilities, overdraft drawing, signing the application for loans, bank facilities, collecting the same in his personal name, company's names, etc., etc.
Yes, I mean the question, or I have about that, is that does not appear to authorize Mr. Adas to sign Mr. Al-Barghouthi's name to a document. It seems to authorize Mr. Adas to sign either his name or the name of the company.
Or the name of the company. Even for the purpose of a civil, my respectful submission is that later the forgery definition we have seen, where with a consent, if there is no consent, with a consent, because the document of Dubai police only doesn't talk about forgery. The document relied upon by my learned friend, the fifth defendant, is basically talks about it is not his signature. There is no conclusive proof as to the question of forgery. And to read with, if we are reading it along with 5, which says that with consent or without consent, if a person is putting signature with consent, which is purely a matter of right, not at this stage, that is my respectful submission so far as that issue is concerned.
Yeah, can I clarify
yes,
something? Because Mr. Ghaffar essentially submitted that you don't challenge what is said in the police letter, and that the police letter essentially says that the signature, which purports to be that of Mr. Al-Barghouthi under the rubric of personal guarantor 1, was not affixed by him. So can you tell me whether you challenge that or whether you accept that and that the court it takes that as a binding finding of fact?
Not at all. With great respect, I completely deny the statement, and my respectful submission is that has been taken out of context. One line, of course, it's not a.
So what do you? Sorry, what do you deny? What do you deny then?
I say because it's a normal banking transaction. It's a signature of fifth defendant. That is the normal KYC procedure which I followed, and signature of the fifth defendant, and also the fourth defendant, the other guarantor.
No, look, we're going off piste a bit there. I really just want to know whether you accept the police letter as proving that that signature under the words personal guarantor 1 was affixed by Mr. Barghouthi or not.
With due respect, my statement is the signature is by Mr. Barghouthi.
So you say you don't accept.
I don't accept.
You don't accept the police letter.
Yes.
And it's your case, the signature, and it's your client's case that the signature is genuine. Is that correct?
Signature is genuine. And my respectful submission is, as earlier put it, the fundamentals of the prosecution is that it's only a police, thereafter prosecution, and for a honorable court to adjudicate the issue. We are only at the stage of a police report. And that too only says that it appears to be not his signature. It can be, because there is an admission. There is also an admission, and the clear statement of fifth defendant is that he has nothing to do with this particular bank. He has no relation. That's a very unequivocal statement by the fifth defendant. But at the same time, it is also a common record that he transferred his shares. So he admits the fact that he's holding 51% of shares. And he says this incident happened on 4th of January 2016. And in April, he says that he divested the shares. So he says the pledge document, which is not an issue here, the pledge document, the account pledge document refers to facility agreement, refers to the guarantor. Kindly see that document, which I can take you. It is not a document in isolation.
Yes. So do take me to the document to make your point.
Please. I'll just take it. Asset pledge document is at 3-171.
Okay, let me just get that up.
3-171, running page 558.
Okay. Yes, I have that.
Yes, kindly see 3-172.
Yes.
It talks about the asset pledge agreement is made on 4th January 2016. And kindly see the background, bottom. Under the terms, this is the same agreement, the facility agreement as well. And the background, under the terms of the facilities agreement dated on or about the date of this agreement, that is 4th, facility agreement in bracket, between the grantor and the bank agreed to provide certain credit facilities up to $12 million. 12 million US dollars. Then kindly come to the bottom of that document. That is at 3-188. Running page 3-188.
178 or 188, sorry. 188.
188. Yeah. That is running page 575 on the left-hand side.
Sorry, I'm just scrolling down. It's a bit slow on the internet.
I'm sorry.
That's all right. No, I've got it.
So this document, the fifth defendant is not relying upon this document. The fifth defendant says that this claim should be dismissed and there should be a summary judgment only confining to the facility agreement. And he says,
sorry, just pausing there.
Yes.
So do we say, is it your client's case that when we look at that, it says signed by Mr. Al-Barghouthi.
Yes.
There are two signatures there.
3 signatures.
Again, I don't pretend to be a handwriting expert, but it appears to me that the one on the left is Mr. Adas's and the one on the right appears to be Mr. Al-Barghouthi's. Is that right?
Absolutely. And this is signed in front of, kindly see the bottom, DIFC Register of Companies.
Well, I don't know whether signature confirmation in the presence. Okay, yes.
But for the preliminary and primary purpose, for a prima facie, it appears it's a matter of trial. But notwithstanding that aspect, these signatures were put before the Register of Company of the IFC. And this document refers to the facility agreement. So the irresistible conclusion can be that the facility agreement is signed by
Sorry, it doesn't say the signatures were affixed. Yes, affixed.
Yes, yes.
Yes.
Affixed in my presence on this day.
Yes.
So, and I would like to repeat that this document refers to the facility agreement.
Yes.
So, in that context, my respectful submission is that prima facie, it's not a case for a summary judgment. It's a matter of trial. Otherwise, we would be doubting the DIFC registrar, the proceedings of DIFC registrar himself. The whole process of attestation of the documents, that's also a public authority. That is also a formal document.
Okay.
There is nothing to shift the burden. He has not established a case shifting the burden on me to prove that, to prove whether it is forged or not forged. My case is simple, straightforward, a recovery claim. And for a recovery claim, I'm not extending my argument to that extent. Still, I say, even if you leave out this signature of the defendant, still he is liable because of the power of attorney. You can ignore the signature straight away.
Well,
I'm only, it's a far-fetched argument. I'm not harping on it. Only for the purpose of arguments, I'm just taking to that extent.
yes.
Because it's a sin.
Well, the power of attorney does not appear to authorize Mr. Adas to
put his signature. The power of attorney authorizes on his behalf.
Yes, to put Mr. Adas's own signature or the company's signature.
Adas has all the authority of even fifth defendant.
Sorry, you broke up slightly. Forgive me. It's
I'm so sorry. Adas had all, the fourth defendant had all the authorities of fifth defendant.
Yes, that I understand. The issue is whether or not it entitles him to sign Mr.
Yes,
Barghouth's name rather than his own name. And it doesn't appear to do that.
That is also a matter of trial, as my learned friend has put it, that one way of looking at the case. When there are two ways of looking at the case, particularly at this juncture.
Yes.
Unless there is a conclusive nature of evidence, which doesn't come under the realm of evidential assumption, a summary judgment may not be granted, because what has been relied upon is a report of a report in the nature of a hearsay. And there is no case that all other signatures are also forged. Very specifically, in the skeleton argument, the plea has been taken that all other agreements, all other documents are irrelevant. That is 4-18. Running page 711, 4-18.
Yes.
Which says irrelevant matters. Whether or not DeFi signature has appeared on any of the other documents that are in the evidence before the court today, that is account opening for the resolution of the board, asset pledge agreement, account pledge agreement, personal undertaking, and sanction letter of April 2016 are genuine or not, all of which is any case also strenuously denied by D5, is of no relevance to this issue. And all this evidence is extraneous to the singular question before the court and of no assistance whatsoever. So when there are multiple documents pointing towards banking transaction, and he is the beneficial party.
But those, forgive me, but those documents are irrelevant in the sense that they don't prove whether or not the signature on the document, on the facilities agreement, is genuine or not. They may be relevant to the issue as to whether it was authorized, but this submission is right to the extent that only forensic evidence can prove whether the signature is genuine or not.
That is, my argument is only for the purpose of addressing the summary. Is prayer is for a summary judgment.
But let's take it. I mean, let's take it more widely. So, as you say, this is a recovery case as far as the bank is concerned. But then the issue of forgery is raised, and they raise the issue of forgery based on the police report. You tell me that you don't accept that the police report proves that the document is a forgery, and you say the signature is genuine. I'm just extremely surprised that your clients have not then gone on to get their own forensic science report on the signature, because surely the question of whether or not the signature is genuine is a matter for document examiners.
I'm afraid that it's the responsibility of the fifth defendant as a matter of defense. As a matter of defense, he has to prove that the document is forged. For me, it is not a matter of forgery.
But what if I find that I'm bound by the police report in the absence of any contrary evidence? Well, let's assume that it's not totally binding whether there's contrary evidence or not. But let's assume that I take the view that it is evidence. I don't require somebody to speak to it, but I will take the report on the record if and when it's produced, and if the fifth defendant does ask the court to obtain it. And so I obtain it. It's an official document. And the court says, well, in that case, we take it on the record, whether we're under UAE law or applying English law pursuant to the DIFC evidence law. So where does that leave you?
Yes. Kindly come to 5-1, running page 354.
Sorry, what page is that?
5-1.
Yep. Okay.
354. This is the letter by Dubai police.
Yes.
Which says, with reference to our letter dated so-and-so, regarding the transaction number Bad Dubai police station. Bad Dubai police station extends its warm greetings, etc. Pursuant to your letter dated so-and-so. Regarding the inquiry of transaction, we notify you that the investigation is still ongoing in the complaint for information and action.
Yes.
So my respectful submission is that there is no conclusive nature. The investigation is still going on.
But that's the investigation. It does. I mean, the investigation may be on the basis of a report that the signature, for want of a better expression, or to use a shorthand, was forged. So,
yes.
So let's assume I take the report on the record. It's self-proving as an official document, and let's assume also that I decide, or the trial judge, whoever that is, decides that it's evidence, but it's not conclusive. It can be contradicted. If you don't lead evidence to contradict it, then it is an uncontradicted piece of evidence that the document that the document contains a false signature. Where does that leave us?
I follow the question that necessarily I should also ask for a forensic evidence.
Well, it's a matter for you. It's a matter for you what
yes,
you do.
Yes, that's true. I follow that. I follow that question with great respect. But my respectful submission is that even the Dubai police report only talks about that the signature doesn't match. It's not forgery. The word, for the purpose of non-suiting me, it should be a case of forgery. The letter, admitted letter, which talks about if it is taken on face value, doesn't appear to be the signature. It can be a signature with authorized authority, or it can be a varied signature, because he admittedly, he says he was not actively involved in the business transactions. He might be a person who may not be signing at least for 2 years or 1 year. I'm just presuming signature can vary. I don't have a case like that. What I'm saying that the irresistible conclusion can be that a signature does vary. It's not forgery. There is no conclusive nature of evidence as to the question of forgery, even by the letter of the Dubai police.
Now, it's a question, in fact, I will ask Mr. Ghaffar, and should have asked him earlier, but I ought also to give you the opportunity to comment on it. There is a suggestion in the evidence in Mr. Al-Barghouthi's reply witness statement that Mr. Adas has admitted that he illicitly attached the signature to the document. Do you have any knowledge or any submission on that? Do you want me to repeat the question?
Your Honor, I think he's no. He's
And
not
did you not hear me? Can you hear me? Can you hear me? Mr. Ghaffar, can you hear me?
I can hear you fine, Your Honor.
Yes. Mr. Dinesh, can you hear me?
Yes, I can.
Okay, I'll repeat the question if I may. There is a suggestion in Mr. Al-Barghouthi's reply witness statement that Mr. Adas has admitted that he illicitly signed the facilities agreement naming Mr. Al-Barghouthi as the guarantor. Do you have any knowledge or any comment upon that evidence? Can you hear me, Mr. Dinesh?
I can hear.
Yes. Did you hear my question?
Yes, the question was put to Mr. Ghaffar.
No. I said I will.
I'm so sorry.
No, I said I will ask Mr. Ghaffar when it's his turn to reply.
I'm so sorry. I'm sorry.
And that I should have asked him earlier, but I'll ask him when you finished. So, did you heard the question, or do you want me to repeat it?
I'm sorry. Kind enough to repeat.
Okay.
Please, kindly.
So it's stated in Mr. Al-Barghouthi's Mr. Al-Barghouthi's reply witness statement that Mr. Adas has admitted that he illicitly signed the document naming him as the personal guarantor. Do you have any comment on that or any knowledge about?
It's a matter between. Yes, I'll respond to the question.
Yes.
My respectful submission would be that it's a matter between fourth defendant and fifth defendant. And purely, I'm not privy to the transaction. For me, fourth defendant is a guarantor and fifth defendant is a guarantor. I've not raised an allegation that they were colluding each other against the bank. I've no case like that. We don't know. But for me, they took advantage of the facilities. They enjoyed the facilities. Fifth defendant, 51%, and fourth defendant, 49%. And all along, there was no complaint against any of this transaction while enjoying. And this forgery, the issue came up, and the Dubai police complaint was filed after 3 years, almost 3 years. And this, when the check was bounced, notice was sent to fifth defendant.
Sorry, you're going to say when the check was bounced. You're going to have to help
Yes.
me with what that refers to.
Yes. There is an allegation against me that the check was not, as Mr. Ghaffar has put it, that the check was not signed by the fifth defendant. Check was admittedly signed by fourth defendant.
What check? What checks are we talking about here?
When it was taken, the facility was taken, there was a guarantee check. The check is also already on record. I'm sorry, I take some time.
No, take your time. We've got plenty of time.
Yes. I'm obliged. Kindly come to 1-154.
Yes.
This is a letter dated 3rd January 2019. And kindly come to.
Sorry. Yes, I have it. Yes.
Yes. This is in notifying the default. And this letter was addressed to, kindly see 1-158. And specifically 1-159 to Mr. Barghouti. Yes, that is third. And this was on 3rd January 2019. And the complaint was filed only in 2021. So he should have, why he has not prepared a complaint before that? And the answer of fifth defendant to this was that the letter was not served on him. This particular letter was not served on him. And the claimant answer against this was that it was served on the address of DEWA, Dubai Electricity Company.
Yes, I know what DEWA is.
DEWA. So the utility address, it was served on utility address. And it was sent by mail as well, email. So.
And sent by email?
It's sent by email as well.
Mm-hmm.
So in that case, why he had not prepared a complaint straight away?
Mm-hmm.
And in this context, I would like to emphasize the fact that he says that he resigned from the company activities on 20th April 2016. And then he says he's not aware what transpired after April 2016. And presupposes the fact that he was involved till then in the company. In the light of asset pledge agreement, in the light of facility agreement, in the light of bank opening statement, in the light of admitted power of attorney. Power of attorney is not defined. Power of attorney is not denied, even now. Existence of a company is not denied. Transaction of a company is not denied. Facilities given by the bank, claimant is not denied. So, since all these documents are not denied, all these banking transactions are not denied, the facilities enjoyed by the defendant number one company and the beneficiaries of defendant number one or clients of defendant number one, they were all given facilities or paid by the claimant. And it comes to when the whole dispute arises only when there is a default. So the whole defense comes upon of forgery, notwithstanding the fact that a signature in front of the registrar of the IFC, a signature was put in his presence, affixed in his presence, and that document refers to the facility agreement, which shows that the whole these activities would show that it's a signature of fifth defendant, and fifth defendant is a party to the whole transaction, is liable. So my respectful submission, I won't be taking time. My respectful submission is that since there is no admissible evidence, based on an evidential assumption, particularly which involves a question of fact on many aspects, the issue cannot be decided in isolation. And not entitled for a summary judgment. That's my respectful submission.
Those are your submissions.
Thank you. Yes, my submission.
Okay, well, thank you very much. That's very helpful. So back to you, Mr. Ghaffar, in reply. And can I first of all ask you the question I should have asked you and ask Mr. Dinesh? What do you say about that evidence that Mr. Adas has admitted illicitly attaching the signature?
Well, Your Honor, we say that evidence should be taken at face value. There is no reason to go behind it. The evidence is in response to, I believe, paragraph 14 of Ms. Bini Saroja's witness statement, in which she says the and that's at 3-134. The claimant had received the call from the police station that the file has been closed. The police had asked about the issuance of the power of attorney to the fourth defendant by the fifth defendant, which had been confirmed. Based on this, the police decided to close the file and concluded that the fourth defendant had signed on behalf of the fifth defendant on the loan facility agreement. The DIFC may issue a letter addressing the Dubai police requesting for the said decision. Now, it's in response to that conclusion that is being reported by Ms. Bini Saroj that the fourth defendant had signed on behalf of the fifth defendant on the loan facility agreement, as Ms. Bini Saroj says was reported to her by the police, that you get the evidence of the
7th of March. So what I drew from this was that the police, first of all, said they were closing the file on the basis of the power of attorney. Your client then went to the police, I think in January, and persuaded them that Mr. Adas had admitted that he'd forged his signature, and so the police reopened the file.
Your Honor, I think that's correct. And I think to the extent that you have the letter from the police at 5-1, 5-2, in which they say that the investigation is still ongoing, that is a response to a letter from the DIFC court to the police dated the 16th of February 2023.
16th of February it is, but I'm talking about an earlier period. I think the police, again, I'm speaking from memory from what I've read, that I think it reconciles the chronology that Mr. Roach was talking about there, that in December they told her that they closed the file, but in January I think your client went to the police and said and persuaded them to reopen it on the grounds that Mr. Adas was an admitted forger. Is that fair?
I think that's fair, save to this extent that she asks at paragraph 5 of her witness paragraph 14 of her witness statement at 3134 that the DIFC court may issue a letter addressing the Dubai police requesting for the said decision. And it would appear that the DIFC court has then issued that letter in February of that month, and the Dubai police have come back and said the investigation is still ongoing, the case is not yet closed.
Yes, because it had changed in January, I think.
Your Honor, precisely, yes.
Yes.
As a matter of chronology, that's correct.
Yes.
But the Dubai police, it would appear from the evidence of Mr. al-Baghuti at paragraph 18 at 3305, have concluded that where Mr. al-Barghuti's signature appears on the documents, that has been actually written by Mr. al-Adas.
So that's paragraph 18.
Your Honor, yes.
I noticed that your client used the plural in his witness statement, documents rather than document. But the police document, I mean, we've been over this before, but of course the police letter doesn't. So I met the police, yes, 16th January. He does repeat the allegation that the claimant is implicated in the conspiracy. Yes, sorry. Do continue, Mr. Ghaffar.
So, well, Your Honour, we say that there is nothing to go behind that evidence. Mr. Dinesh has not contradicted it in any way, and that is a report of what the police have said to Mr. Al-Barghouti as to the signature that appears on the documents that appears to be his signature that has been written by Mr. Al-Adas.
So, and that's in, sorry, I'm just reading, and that's in paragraph 18.
Your Honour, yes. The police confirmed that the said complaint shall be reopened to further investigate the actions of the fourth defendant, signing on behalf of defendant number 5, imitating defendant number 5's signature, instead of following the obvious practice to ascribe his own signature, along with mentioning for and behalf of defendant number 5 as his attorney.
Yes, but where, sorry, you said before that the police said that they'd found that the signature on all of the documents was not genuine. I couldn't find that in this paragraph.
The disputed documents, Your Honour, are all of the documents that are in question.
So please confirm that the complaint shall be reopened to investigate the action of signing on behalf, imitating, instead of the following. But there's no evidence, but I fourth defendant has stated, paragraph, I say, at least, yeah, your client says that he'd signed all of the documents, but there's nothing to indicate that the police have come to that conclusion yet. They may do.
Your Honour, yes, I have to accept that they are still investigating the matter on that basis.
Okay.
But Your Honour, the fact remains that as Your Honour was pointing out, the power of attorney doesn't give Mr. Al-Adas any authority to actually imitate the signature of Mr. Al-Barghouti. It simply authorizes him to sign on behalf of the company or using his own signature.
Yes.
So the appearance of Mr. Al-Barghouti's signature on the facilities agreement has plainly, according to the Dubai police, not been affixed by him himself, and it would appear that it has been affixed by Mr. Al-Adas.
That seems probable. Assuming he didn't affix it himself.
Absolutely, Your Honour, but the Dubai police clearly say he didn't. So, Your Honour, we go back to the question as to whether or not the fifth defendant is likely to have authorized or consented to his signature being affixed on a document by Mr. Al-Adas, imitating his signature. And Your Honour, in light of the fact that there is a power of attorney which authorizes him to sign as an attorney.
Why would he copy the signature?
Precisely, Your Honour. And that is why the police investigation has been reopened.
Can we just run through the scenario that I put to Mr. Dinesh? So let's assume that you have asked me to get the court to obtain the police report itself rather than a second-hand account of what it says. We get the police report. I accept that I can take it, I can receive it in evidence without the maker being called to prove it. It is then in evidence, but you would argue it's conclusive and cannot be contradicted, which is a matter, you say, of UAE law. The court may determine that that's not right, that under the law prevailing in the DIFC, it is certainly evidence, but it is evidence that is open to be contradicted. If Mr. Dinesh's clients do not choose to get their own forensic evidence, they're stuck with the police report. If they do choose to get their own forensic evidence, they could contradict the police report, couldn't they? Subject to your point about its conclusivity. Or conclusiveness, I'm sorry. Conclusivity is probably not an English word.
Your Honour, yes, but for the purposes of this hearing today, Your Honour, we would refer you to the words of the Court of Appeal in both the IGPL and the Sir Said Suleiman Mohammed Al-Mazri against Baghdad case,
where they've looked at Lord Justice Bick's words in the Korean case.
Precisely, Your Honour.
Yes.
And it is incumbent on the respondent to not be complacent in an application of this kind, and to at least indicate that the evidence at trial will be different, and to indicate the sources of that difference before it discharges its evidential burden.
Yes.
Which it just simply has not done. And there is no indication whatsoever that it will obtain a forensic report. Indeed, the point in time at which it could have done so before it submitted these documents to the police, because now the documents are with the police, the originals are with the police, and they are in the custody of the police, and they won't be released back to the parties until the police investigation is concluded. And if the police investigation concludes that the documents are forged, there will be a public prosecution brought, and at the conclusion of that prosecution, if the individuals prosecuted are found guilty, the documents will be destroyed and they will be found to have no effect. So the opportunity now to get those original documents back into the hands of the parties has effectively been lost. And that is the fault of the claimants for not having commissioned expert evidence at the appropriate time when they should have done so. We, of course, have the original expert evidence that we submitted in the Dubai Civil Court, and we submitted as part of our complaint to the police, and we could, of course, rely on that as additional expert evidence in this matter. But the claimant has no longer any opportunity to submit any expert evidence, and that is its own fault for not having commissioned that evidence at the appropriate time.
Yes.
So we say that on this application, it is incapable of discharging its evidential burden.
So you would say that on this application, it's not open, or there's no realistic prospect of the claimant rebutting your case that the signature to the facilities agreement was not affixed by Mr. Al-Barghouthi.
Absolutely, Your Honour, yes.
Okay.
Your Honour, it's all very well for Mr. Dinesh to say in submissions that they don't accept the police letter, which I believe he did say.
Yeah.
But they need to put in some evidence to contradict that letter, and they're not now capable of obtaining that evidence.
Yes. Okay.
Your Honor, the only other point that Mr. Dinesh made in his submissions that I think I need to address you on is why did we wait until 2021
Yes.
before making any complaint to the police? Your Honor, the position on that is quite simple. The claim before the Dubai Civil Court was begun in 2019 before it was dismissed for lack of jurisdiction in 2020. Now, the claimant is on record as having said, and this I believe is at paragraph 20 of its reply, page 1-319, that we brought forth the forensic report for the comparison of our signatures, of D5 signatures, before the Dubai Civil Court. The claimant wishes to highlight that the fifth defendant had raised the allegation of the documents bearing his forged signature before the first instance court in case 829/2019 and brought forth the forensic report for the comparison of his signatures. Nevertheless, as per the expert report issued by the Dubai court, the fifth defendant was found jointly liable along with the other defendants to pay the outstanding dues to the claimant. So the issue of the genuineness of the signature has been addressed by us, according to the claimant, before the Dubai courts. The Dubai court then declined jurisdiction over the matter. And the next we heard about it was that there was an issue in this court in which the signature was being claimed to be genuine. And that is the moment at which we went and complained to the police. That, Your Honor, as a matter of fact, there is no record in the banking expert's report that he had been shown any forensic report. And whether or not that was submitted to the Dubai court, it is still open to question, but it would appear that, according to the claimant's pleaded case, it was. So, Your Honor, there can be no issue as to us sitting on our hands waiting for some sort of default before we raise the issue of forgery. The first occasion on which we became aware of this signature being relied on as genuine was when the matter was brought before the Dubai courts. According to the claimant itself, we raised the issue of forgery before the Dubai courts. The Dubai court declined to deal with the matter because of a lack of jurisdiction. And the next occasion on which the issue was raised is before this court. As soon as it was raised before this court, we went and complained to the Dubai police as to the alleged forgery, and they have commenced their investigations and issued the letter dated the 10th of November 2022, addressed directly to the DIFC court.
Okay.
So, Your Honor, in those circumstances, we say that this is a very straightforward matter. The sole issue is whether or not we are liable as a guarantor. And the evidential burden is on the claimant to establish that the signature, not to establish that it was genuine, but to put forward some evidence or even some indication that there will be some evidence at trial that suggests that the signature was genuine. And it simply has not discharged that evidential burden. So in our submission, we are entitled to summary judgment. There is no other compelling reason why there should be a trial. There are no circumstances that ought to be investigated. There's a single issue before the court. And on that issue, there is a police letter which quite clearly concludes that the signature is not that of Mr. Al-Barghouti. Having conducted a forensic technical analysis, and that we say should be the end of it.
Anything else?
Your Honor, I think that's it. Let me just seek instructions,
No, of course.
if I may.
Again, take your time.
Your Honor, I think that those are our submissions, and I would be repeating myself if I was to go back on anything else.
Okay, well, thank you. Can I just raise one more matter, and it's this, first of all, with you, Mr. Ghaffar, costs. Neither party seems to have served a cost schedule, so there will not be an immediate or summary assessment of costs. But what do you say about costs?
Your Honor, my understanding is that we attempted to file our cost schedule on the case file portal, but due to technical difficulties, it wasn't possible. I haven't seen that cost schedule. So in those circumstances, although it's not necessarily the usual order that the court would make on an application of this kind, we would ask that the costs be subject to a detailed assessment if not agreed.
And you would say they should simply follow the event of the application?
Your Honor, yes.
Mr. Dinesh, what do you say about costs?
Yes, regarding the cost, in fact, I've been instructed to argue. In fact, I'm unaware that whether my briefing lawyers, they filed it or not. I'll just check it. But so far as I leave it to this honorable court to decide on that issue.
Okay.
And before that, can I add one more sentence, if this honorable court permits?
Yes, of course you can. Yes,
Yes.
I may give Mr. Ghaffar the right to reply.
Yes, yes. In the case of if we go to trial, we will be examining, or we'll have to examine the IFC registrar, the person who went and collected the signature for the KYC documents, and those people who are involved in the transaction, because there is a whole complex facts involved, transactions involved, the parties who got the benefit, their clients, whether they were actively into business, because they all got the advantage from this facility arrangement. So this is a matter of trial. That's my respective submission.
Okay. Anything you'd like to add, Mr. Ghaffar?
Your Honor, no, I just simply want to reiterate that those issues will not be relevant to the single issue that is before Your Honor today, and that will be in issue at trial as to the personal liability of the fifth defendant as a guarantor of these facilities.
Well, thank you both very much for shedding light on this case. Mr. Ghaffar said it's straightforward. It may be after a detailed analysis, but you have to spend a long time getting there, and I'm very grateful for both of you for your submissions, both in terms of content and economy. I've not, I hasten to add, found this altogether easy. It'll be about a week, I think, before you have my written judgment on the point, but as I say, I'm very grateful for your submissions, and I shall reread all the documents to which you have directed me. Thank you very much indeed. So with that, unless there's anything else, I'll close the proceedings. Nothing else?
We're grateful, Your Honor.
No, thank you very much and have a good day. Thank you.
Thank you.
Bye.